Hi, this is Lee from the Law School Toolbox. Welcome back. We've talked before on this podcast about how to make the most of going to office hours. We know sometimes law students feel intimidated or just aren't sure how to get the most out of going. If you're interested in that conversation, you can check out one of our previous episodes linked to in the show notes. Today, we're doing something a little bit different. We actually got a request recently from a law school professor who noticed that students are not meaningfully engaging with the feedback they're giving in office hours. You as a student are spending time to go to office hours. Your professor is spending their time talking to you. How do you make sure that interaction is a productive one? Well, from a professor's perspective, what can you do to make sure office hours are as meaningful as possible? Let's jump in. First things first, before you head into office hours, it's your job to do the legwork. We've said this before, but if you show up to office hours and say something like, "Can you explain battery to me?" you'll probably be met with a response along the lines of, "That's what class is for," or "Have you not done the assigned readings?" or just plain, "No." From a professor's perspective, a question like this sounds like you're saying, "I don't understand, so that means it's your job to spoon feed me a special class outside of lecture until I get it." You can see why they might be less than enthusiastic. Contrast that with a specific and well-thought-out question that shows you've put in the effort already. Maybe you say something like, "Hey, in that case about the little boy that pulled the chair out from under that old lady, I didn't understand how that could count as battery since he never touched her." And your professor will know, 1, you read the assigned case, 2, you understood what the legal issue was supposed to be, and 3, that you tried to figure it out yourself but just got stuck. Most law professors will probably follow up your question with a question. For example, "Okay, well, which part was confusing exactly? Are you saying he shouldn't be liable for battery because he was a young child, or because there was no hands-on contact with the plaintiff?" And then you two have a conversation about exactly what your professor wanted you to get from that particular case, which will then give you a rule that you can use in the R part of an IRAC on battery on your exam, if that issue is tested. So long story short here, don't swoop into office hours with empty hands and say, "Help me." Instead, prepare a specific question that you have tried to figure out yourself but are still confused about. This should be on a topic your lectures have already covered. Otherwise, your professor may just say, "Wait for lecture. It will all be clearer after that." Show them precisely what you're having trouble with and see if they can help clarify. That's easier for them and much more useful to you. Another thing you might think about doing is giving your professor a heads up ahead of time. For example, if you're not sure if they're amenable to looking over your written work, or if you have something you've come up with that you want their opinion on, why not email them a few days before? You can say something like, "I've drawn up this flow chart that I think could be useful in figuring out personal jurisdiction, but I'm confused about the terminology for minimum contacts, since sometimes the courts say different things. Do you think we could talk about what I am missing in your office hour on Thursday?" Then, unless they tell you no, bring your chart to office hours and give it a shot. Say, "Hey, I was hoping you could clarify the difference between specific and general jurisdiction because I'm a little confused about the idea of where purposeful availment fits into that." What is really helpful in a situation like this is that your professor, who, as you know, is the person grading your exam, can take a look at your chart and say, "Actually, for purposes of our class, we talk about systematic and continuous first and look at whether the defendant is essentially at home in the forum. That's separate from purposeful availment." And look what you just got. some key buzzwords for your rules that you can now discuss more and understand, but then also memorize and use on your later exam. Look, the reality is that courts discuss the same legal issue using different terminology all the time, especially in areas of law that have evolved over time. That's why we always tell our students, use the language your professor uses. Follow the steps your professor sets forth in class. If they want you to talk about X before Y, then it doesn't matter what your supplement or the casebook or anyone else says, because they're the one grading your exam. So give your professor a heads up if you're planning on bringing something for them to look at. Come prepared and pay attention to their terminology and the order in which they discuss issues. Whenever I ask my students, is your professor open to giving you feedback on your practice writing? Guess what their response is 9 times out of 10? I don't know. It never really came up. And it's not going to come up. Most professors are not so generous with their time that they throw out a blanket offer to give written feedback on any practice writing done by any of their hundreds of students. However, a lot of the time, they are more than willing. They just expect you to take the initiative and ask. So think of it from your professor's perspective. They want to help. They have lots of students in lecture and limited time. They're probably not going to individually offer some students help. They're not offering everyone else because that wouldn't be fair. But if you say, I wrote this practice hypo and I'm struggling with figuring out how to explain why acceptance of this offer fails, could you take a look at this? They're likely more willing to help. There are also a couple of tips you can use here. As we've said on this podcast before, do not bring in your writing based on hypos your professor has never seen. Use their hypos from class that they've given to you. That way, you're sure they know the ins and outs of the facts and can jump right in. Also, you can print your writing out so you have something to hand them, which can make it more likely that they will mark or pinpoint exactly where you're going wrong. Plus, some professors are just old school and don't want to evaluate your writing off your screens as you sit there awkwardly holding your laptop or iPad out to them. If it's just one quick write-up and it's a hypo they wrote, and if it's on paper, they can quickly and easily spot where the problem is. So the takeaways here are, don't put your professor on the spot because it will be a less productive interaction. Use a hypo they wrote. Don't assume they're willing to give you feedback if you haven't asked. Don't send them a bunch of attachments or expect them to read through a long document off your laptop screen. Don't show them your 15-page outline and ask them if they think you're doing a good job so far. How are they supposed to know what's going to work for you? Don't leave it open-ended and just ask for their general impressions of your writing. Be specific about what you're struggling with. Ask why this issue fits where it does in the big picture. Ask why one particular fact plugs into one particular element of the rule you're trying to apply. Another opportunity I think a lot of law students miss is asking about other things besides black-letter law in office hours. For example, as we've said, this person you're talking to in office hours is the one who will decide if your exam hits or misses the mark. It is absolutely crucial that you know answers to questions like, is there an order to how these topics should be discussed in an essay on a final exam? Am I supposed to stick to a strict IRAC or modify it to make it shorter? Do rules need to be verbatim what the professor said in class, or can I formulate my own rule statements? Are there abbreviations that are fine to use, or should I spell everything out? Do I need to know precise case names, or can I just say the case about 2 boats or the case about the fox hunt? Now, we're not saying you should ask these questions in this way, and please don't email your professor this list of questions. But do try to get answers to these types of questions in office hours. For example, in office hours, you could ask something like, in an exam scenario, are there separate points available for an accurate rule statement? Or can an exam taker, in theory, get full credit for discussing application of a correct rule without actually stating a standalone rule statement first? Or, I'm struggling with the step-by-step attack plan for formation of a contract, and I'm wondering if topics like lapse and counteroffer are supposed to be discussed, if and when they come up, as some parts to offer or under acceptance. Or, is the approach to long-arm statutes to briefly discuss them every time, no matter what, or only if the given facts explicitly mention that the jurisdiction has one? Again, all of this works better as an in-person conversation, so you can ask follow-up questions. And you can see how information like this can be very useful to you as you write practice exams and on your finals. Plus, a lot of these questions you have may not have a right or wrong answer. Every professor is different. At my law school, there was a torts professor who only accepted wording for intentional torts in her exact language from class. No exceptions. You could not get full credit on a rule statement if it did not conform to that exact wording. Another professor at my school said, I don't really care if you state the rule or follow IRAC. What I want to see is that you can apply an accurate rule to the given facts and explain to me how and why they fit together and what the problems are. Both exams were difficult, but using one professor's approach for the other professor's exam could have potentially cost a lot of points and wasted a lot of time. One method is not correct or incorrect. Some of this comes down to personal preference, so it's up to you to find out exactly what is expected. And a word to the wise here. Don't barge into office hours and ask, will this topic be on the exam? Or, how do I get max points on your test? Again, show you've done the preparation. Ask specific questions. Read the room. Another scenario in which students can get a ton of bang for their buck in office hours is in legal writing classes. Actually, this goes for any class where you may have cumulative assignments that you work on in smaller chunks throughout the semester, but then turn in a final version at the end. In these situations, it really pays to make sure you understand each round of preliminary feedback before you go to draft your next version or craft your final project. For example, in a lot of legal writing classes, you can lose points for citation errors. So if you see you got marked off for a citation on round 1 of your paper, go figure out why. Obviously, come up with a theory of your own first. Maybe that comma was not supposed to be italicized. Yes, that's a thing. But maybe there were other things wrong too. Take your presumption to office hours and ask your professor, hi, so I noticed I lost a point here. I think it's probably because this comma was italicized and it shouldn't be. But if I fixed that, would this get full marks or am I missing something else that I'm just not seeing? They took the time to mark your paper. They want you to understand the problem and fix it. They will be happy you asked for clarification. Same thing for more substantive feedback. If your professor said your argument on a draft writing assignment could be stronger, well, why do they think that? What made it weak in the first place? What exactly is the problem? Could you redraft just that portion and ask your professor to assess whether you improved the strengths of that argument or not? Do they have an example you could check out? There was a student in my law school who got marked off on a legal writing assignment for misstating the same fact over and over again. The word was macrame, and he kept writing macaroons. There was a person in the professor's fact pattern who was selling macrame items, like woven craft project type stuff. And this student just assumed they were selling cookies and talked about cookies whenever that fact came up in their answer. It wasn't even that crucial of a fact in terms of a legal argument, but it annoyed the professor and looked sloppy. He could have figured out in office hours that he was doing that, even if he couldn't see it himself. That's what office hours are for. Figure out where you're weak before you have to turn in the graded final version. We know from working with students that seeing the same error again and again when you've already taken the time to correct it can be aggravating. It just makes it look like the student isn't trying. Things like weak legal arguments or not using the facts effectively can take lots of time and effort to fix. However, if it's the fourth iteration of a paper and you as a professor are still seeing the word macaroons come up, well, you might just assume this person doesn't care. One more tip for students in office hours is to take notes by hand. Of course, everyone has a phone and most law students use laptops, but like we said before, some professors are old school. If you have your screen between your face and theirs and you're not making any eye contact at all, it can feel from their perspective that you are less engaged. If, on the other hand, you really listen to what they're saying and take brief notes on paper here and there, it will probably be a more productive conversation, and you're more likely to retain what they said in office hours. Just like our advice about lecture, if you're so busy being a stenographer and typing 1,000,000 miles a minute, you're going to miss a lot, in particular, the chance to ask follow-up questions. And sometimes in office hours, your professor might give clues about the topics they're really passionate about, or share stories from their law practice days. And these things have been known to come up on exams. Be attentive. Listen. Get to know this person who is so interested in this subject that they've made it their life's work. Another good use of office hours is to help you find practice sources. If you're struggling with the substantive law and you've gone to office hours and still feel you need to work through some material some more on your own, why not ask your professor for their advice on supplemental materials you can practice on? Some professors will say, all you need is the casebook, just study, but many will have useful suggestions. Some professors even model their questions or take them almost verbatim from published supplements. So, if your professor has a favorite source for your particular class and you ask for guidance, you may even see some similar examples on exam day. Even if that doesn't happen, though, you can still get helpful information if you know which sources your professor thinks are worded properly or organized in the way they organize the topics you're learning about. All right, so we've talked about not just being a passive sponge expecting to soak up information in office hours. We've talked about coming prepared and showing you're doing the legwork. The last bit of advice for office hours is all about attitude. Please don't get defensive. If it comes down between you and your professor, they and not you are probably correct about the substantive law. And even if they're wrong about something, taking a defensive or antagonistic approach is not the way. Maybe a professor really does make a mistake. There are professional ways you can handle that. And believe it or not, this is truly excellent practice for working with future supervising attorneys or your superiors at the office one day. If you say, okay, that's wrong, that's totally wrong, what were you thinking? That is not going to go over well. Instead, you could say something like, okay, so correct me if I'm wrong here. But there seems to be an inconsistency with these two results. Can you help me understand how these answers both work? You don't need to be self-effacing or deferential in a way that makes you uncomfortable, but office hours is probably not the time to showcase your appellate advocacy skills. Use a calm voice. Phrase what you're saying as a question and give them the chance to say, oh, you're absolutely right, that's a typo. And if the mistake was yours, own that and learn from it, rather than trying to convince your professor that what you did is actually the right approach. Again, they're the one grading your exam. If you think something is objectively incorrect, of course, say that. If you got marked off for an issue that you did discuss, point that out and ask what you should have done differently to get more points. But if they're giving you feedback and you're just not willing to learn from it because it hurts your pride to be corrected, or you don't like the feeling of doing badly on something you tried your best at, well, then that's another issue. We've all been there. We've all written a terrible hypo or completely misunderstood a legal rule or really messed up when outlining. And that's why we've talked so many times about fixed versus growth mindset. Take criticism from well-meaning sources like your professors and use that information to do better next time. They really are trying to help. And that's all we have for today. Thank you so much for watching. Please give us a like, leave a comment, and subscribe so you don't miss any future content. You can also learn more about what we do at lawschooltoolbox.com.